All right, continuation, part two of the Redemption Manual. So, which part is this? Federal children. Are we owned by the government? In 1921, the Federal Shepherd-Towner's Maternity Act created the birth registration, or what we know now as the birth certificate. It was known as the Maternity Act and was sold to the American people as the law that would reduce maternal infant mortality, protect the health of mothers and infants, and for other purposes. One of those other purposes provided for state agencies and overseeing of its operations and expenditures. What in what it really did was create a federal birth registry which exists today, creating federal children. This government of parents, Patria, or, or Patria, matter of fact, let me spell that for you. Patriae, parents, Patriae. Now legislates for American children as if they are owned by the federal government through the public school enrollment process and continuing license requirements for most aspects of daily life. These children grow up to be adults indoctrinated into those things necessary to carry out activities that exist in what is called a free country. Before 1921, the records of births and names of children were entered into the family's Bible, as were the records of marriages and deaths. These records were readily accepted by both the family and the law as official records. Since 1921, the American people have been registering the births and names of their children with the government of the state in which they are born, even though there is no federal law requiring it. The state tells you that registering your child's birth through the birth certificate serves proof that she has or was born in the United States, thereby making him, her, a United States citizen. For the past several years, a Social Security number has been mandated by the federal government to be issued at birth. The Social Security number is one of those other purposes. It serves as a means of lifelong tracking of those one name named on the birth certificate. In 1933, the United States of America, corporate government, was declared bankrupt by President Roosevelt. The governors of the 48 states pledged the full faith and credit of each other, or each of their states, including the citizenry as collateral for loans of credit from the Federal Reserve System. To wit, full faith and credit, the clause of the United States Constitution, Article 4, Section 1, which provides that the various states must recognize legislative acts, public records, and judicial decisions of the other states within the United States. And when they say United States here, the way they wrote it is lowercase u, N-I-T-E-D, United, and capital S-T-A-T-E-S. So the capital S in states is capitalized, and the U in United is lowercase. Interesting. Continuing, it requires that foreign judgment be given such faith and credit as it had by law or usage of state of its origin. That foreign status are to have force and effect that which they are entitled in the home state, and that a judgment of record shall have the same faith, credit, conclusive effect, and obligatory force in other states as it has by law or usage in the state from whence taken. Black's Law Dictionary, 4th edition and 6th edition, page 672. Cites omitted. After receiving the information of live birth and other particulars for the birth certificate accompanied by the assigned Social Security number, the state claims an interest in every child within its jurisdiction. The state will, if it deems it necessary, nullify your parental rights and appoint a guardian, trustee over your children. The The subject of every birth certificate is a child. The child is a valuable asset which, if properly trained, can contribute valuable assets provided by its labor for many years. It is presumed by those who have researched this issue that the child itself is the asset of the trust established by the birth certificate, and the Social Security number is the numbering registration of the trust, allowing for the trust assets to be tracked. If this information is true, and we believe it is, our children are owned by the state. Which one of us, including our children, are considered assets of bankrupt United States corporation? We are now the state, we are now designated by this government as human resources, born in a delivery room, delivered to the state of birth by way of the birth certificate for which our informer, our mother, provides the requested information, including the name and social security or tracking number, wherewith this bankrupt government is supplied with new crop of collateral born each year. Page 1 of 3, Federal Children. In 1923, a suit was brought against federal officials, corporations, charged with the administration of the Maternity Act, who were citizens of another state, to enjoin them from enforcing it, wherein the plaintiff averred that the act was unconstitutional and that its purpose was to induce the state to yield sovereign rights reserved by them through the federal Constitution's 10th Amendment and not granted to the federal government, and that the burden of the appropriations falls unequally upon the several states, held that, as the statute does not require the plaintiff to do or yield anything, and no burden is imposed by it other than that of taxation, which falls not on the state, but on its inhabitants, who are within the federal as well as the state taxing power. The complaint resolves down to the naked contention that Congress has usurped reserved powers of the state by the mere enactment of the statute, though nothing has been or is to be done under it without our consent. Commonwealth of Massachusetts versus Melton, Secretary of the Treasury, et al. Frothingham versus Mellon, Secretary of the Treasury, et al. Mr. Alexander Lincoln, Assistant Attorney General, argued for the Commonwealth Massachusetts. To wit, number one, the act is unconstitutional. It purports to vest in agencies of the federal government, a corporation, powers which are almost wholly undefined in matters relating to maternity and infancy, and to authorize appropriations of federal funds, federal funds for the purpose of the act. Many examples may be given and were stated in the debates on the bill in Congress for regulations which may be imposed under the act. The forced registration of pregnancy, government prenatal examination of expectant mothers, restrictions of the rights of a woman to secure the services of a midwife or a physician of her own selection. All are measures to which the people of those states which accept its provision may be subjected. There is nothing which prohibits the payment of subsidies out of federal appropriations. Insurance of mothers may be made compulsory. The teaching of birth control and physical inspection of persons about to marry may be required by Section 4 of the Act. The Children's Bureau is given all necessary powers to cooperate with the state agencies in the administration of the Act. Hence, it is given the power of assist in the plans submitted may provide. Oh, excuse me. Because there's an error. Hence, it is given the power of assist in the plans submitted may provide. As to what those plans shall provide, the financial arbiters are the Bureau and the Board. The fact that it was considered necessary in explicit terms to preserve from invasion by federal officials the right of the parent to the custody and care of his child and sanctity of his home shows how far-reaching are the powers which were intended to be granted by the Act. Number one, the act is invalid because it assumes powers not granted to Congress and usurps the local police powers. McCullough versus Maryland for Wheat. 316, 405, United States versus Cruikshank. 92 U.S. 542, 549-551. All right. In more recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based on one of the powers expressly granted to Congress, which in fact usurps the reserved powers of the states, and that laws showing on their face detailed regulations of matters wholly within the police power of the states will be held to be unconstitutional, although they purport to be passed in the exercise of some constitutional power. Hammer versus Dagenhart. 247, 259, U.S. 44. The act is not made valid by the circumstances that federal powers are to be exercised only with respect to those states which accept the act, for Congress cannot assume, and state legislators cannot yield, the powers reserved to the state by the Constitution. A message of President Monroe, May 4th, 1822. For Eliot's Debates, page 525. Pollard's Lessee versus Hagen, 3, Howe, 212. Ascanaba Company versus Chicago, 107 U.S. 678. Coyle, Coyle versus Oklahoma, 221 U.S. 559. Cincinnati versus Louisville, and Nashville, R.R. Company, 22-3, or 223 U.S. 390. All right, page 2 of 3, federal children. The act is invalid because it imposes on each state an illegal option, either to yield a part of its powers reserved by the 10th Amendment or to give up its share of appropriations under the act. A statute attempting, by imposing conditions upon a general privilege, to exact a waiver of a constitutional right is null and void. Harrison versus St. Louis and San Francisco. Looks like Railroad Company. There we go. R.R. Company. Okay, so Railroad Company. 232 U.S. 318. Terrell, Terral versus Burke Construction Company. 257 U.S. 529. 3. The act is invalid because it sets up a system of government by cooperation between the federal government and a cooperation in certain of the states not provided by the Constitution. Congress cannot make laws for states, and it cannot delegate the states the power to make laws for the United States. In re, Rabrer, Rabrer, 140 U.S. 545. Knickerbocker Ice Company versus Stewart, 253 U.S. 149. Opinion of the Justices, 239 Mass. Was that Massachusetts? Okay, 606. The Maternity Act was eventually repealed, but parts of it had been found in other legislative acts. What this act attempted to do was set up government by appointment, run by bureaucrats with re-delegated authority to tax, which is in effect unconstitutional. What was once declared unconstitutional by the Supreme Court of this nation in the past should be upheld in a court challenge today. The Constitution has not challenged. What was challenged is the way this government views human life. Today we are defined as human resources, believed to be owned by the government. The government now wants us as individuals to be tagged and tracked. Government mandated our legislated national ID, which is unconstitutional. For jurisdiction to be For jurisdiction to legislate for the several states does not exist and could never survive a court challenge, as shown above. Writing letters to elected public servants will not save us, when we all know their agenda does not include serving those who place them in power. Servitude. Perhaps the 10th Amendment of the Federal Constitution guaranteeing states' rights will, if challenged, when making it known that we as individuals of the several states will not be treated as chattel of the United States government or U.S. government, if the federal government believes that they own us and as such have right to demand national ID cards and health ID cards, which will in truth tag us as we tag our animals, then let them bring forth the documents to prove their authority to legislate for it. If our God-given rights to life, liberty, freedom, and pursuit of happiness, which were the foundation upon which this nation was created, do not exist, and liberty and freedom is only an illusion under which the American people suffer, then let the government of this nation come forward and tell the people. But if we are judged free, then we should not have to plead or beg before our elected public servants to be treated as such. If in truth we are not free, then perhaps it is our duty to address this issue forthright and forthwith, with the power of the pen, and pray the people will waken from their fear and slumber induced by greed. Page 3 of the Federal Children. All right, now this is section 2. The American Dream, True Redemption. Okay. The American Dream. The author's view from an understanding for the material that has come from many varied and researched material from many and varied patriots and books written by people recording history as they viewed it at the time history took place. Books are never all factual and sometimes are purposefully slanted by the views put forth by the author. Okay, I've seen this plenty of times. I'm going to go opine on this here statement written. I've seen this plenty of times with theosophy and even in some cases, most cases, theology. But when you put it together, you have theosophy. So you got theology and philosophy, putting that together to create theosophy, and these New Agers, these witches, these Freemasons, these Satanists and Luciferians do that quite a bit when they want to indoctrinate you or get you to compromise your standards or your morals. And they're quite good at that, all right? I mean, their master, Lucifer, is the father of lies. And if that's what our country is going to do, is continue to lie to us while they rape us at every chance they get, then we are not really citizens. We're actually more like detainees and inmates and whatever, just working at the wheel and mill to further their agenda and make them rich. It sounds like slavery in the good old colonial days all over again. But anyway, I shall continue. There are always errors in understanding and books. But most authors take offense at having something pointed out that was written wrong, either for purpose or by mistake. This book is written. It is yours when in your possession. The material is free. Change whatever you like in your book. You will not offend me. Okay. Well, that's why I'm reading it. The American Dream, where did it go? Well, March 9th, 1933, a day that will go down in history in infamy. Spoken on a different day, but applies more surely for this day, by Franklin Delano Roosevelt. For on this day, by the Trading with the Enemies Act and the declaration of bankruptcy by the Congress for the United States, a corporation, the American dream turned into a nightmare. At this point in history, slowly but surely, the bankers proceed by taking over the federal court system. The taking over of the American court system is now complete, as the federal rules can be used in state courts. Congress having never lawfully assembled, Congress having never lawfully assembled after Abraham Lincoln dissolved Congress after the Southern states walked out during the debate over the Civil War, and having never been passed into positive law, now sits outside the Constitution, just as the court system does. This is the reason for the voting registration. For registering, you are given the privilege of voting, and anyone who signs and votes in the federal election or any election are voting as corporate entities, and you are agreeing that Congress has the authority to act from a foreign jurisdiction. Sad. The entire court system is now ruled by and comes under the foreign jurisdiction flag. It is a gold rope, a gold fringe around the edge, or it has a gold rope, a gold fringe around the edge, a gold eagle or gold symbol on top the flag. And now some courts will make a mockery for the United States, again, lowercase u, flag by positioning in a vertical slope. The powers knew that all commerce is ruled by the law of contracts, better known as the UCC law, or the Uniform Commercial Code. Where there is no contract, there is no case. The teaching began in school that a contract, or that any contract you sign, is a valid contract, and that you must fulfill it. This is a good saying as long as it is between two living souls, with all the contract revealed for both parties, and the signature of both parties there too. The heretical saying, good credit is the most important thing that you have. A valid contract has 4 parts. 1, offer. 2, consideration. 3, acceptance. 4, the signature by all parties for the contract. Only the parties that have signed the contract can enforce fulfilling the contract. Without the consent by both parties, a lawyer cannot settle any dispute that may arise from a lawful contract. Our Creator created man. The Creator gave man the right, forming government. Man gave government the right for forming corporations. As man has no right nor the ability for ruling his Creator, the government has no right or the ability for ruling its Creator. An illusion is used by the democracy corporate government, and gave man a corporate name, and made him a legal fiction by writing his name in all capital letters, with the middle name only an initial. The proper name for a living soul is writing in upper and lowercase letters, or writing in upper and lowercase letters. The first and middle name being the sovereign name, and the last name is the family name. The real name for a living soul is I, me, my, or myself. Government being a creation of mankind is only a piece of paper, as the government being a piece of paper could only create a corporation, which in itself is only a piece of paper, neither being able to sign a lawful contract with a living soul. As all governments are corporations themselves, they do not have the ability to sign a lawful contract, for whomever would be so brave make themselves liable for the execution of the contract, thereby losing their limited liability to prosecution for breach of contract. All corporations then must have someone to speak for them, and the government came up with their own solution, the lawyer who has been appointed to speak for all corporations in the courts they have created. The government then came up with a solution to the lawful contract, and it is called the unilateral contract, or a one-signature contract. In their own description of the unilateral contract, it says that they were probably written up by a lawyer or a group of lawyers to commit fraud with the intent to extort monies from the signers. The lawful problem with these contracts, aside from the fact that they only have the signature of one party to the contract, is that they have many hidden traps to which the party is not aware of its contents. In many cases, such as bank contracts of signatures for checking purposes, the contract is never shown to the depositor. All contracts pertaining to the corporation signed by a one-party participant are fraud from their conception and are used to extort monies from the people. They cannot be enforced except with our permission or consent by assent. From the beginning of mankind, they have the right to contract with whomever and whatever they so choose. The government then set their court system apart from the Constitution and its people, and then invites the people to contract with their court system under the foreign jurisdiction flag to allow them to settle their disputes. Of course, since a person to the government is described as a corporation, they then treat any living soul who contracts with their court system as a corporation, and they are a legal person. A slave or debtor cannot speak for itself. The first thing that crosses the minds of parties when receiving a letter from a lawyer, attorney, counselor, esquire stating you have been sued is to run to the phone, call another lawyer, attorney, counselor, esquire to settle the dispute for the two corporations in their court. The judge protecting the lawyers, attorneys, counselors, esquires, and they in turn protect the court, for they are officers of the court. The system is called a legal system, meaning it is legal what they are doing. Legal meaning with your consent. I'll do that for you one more time. The system is called a legal system, meaning it is legal what they are doing. Legal meaning with your consent. After gaining your consent, it then becomes lawful in their courts system for whatever they choose to do with you. Law or lawfulness is constitutional in subject matter, for no law can be enacted or supposed to be. Excuse me. What is wrong? Let's try it again. Law or lawfulness is constitutional in subject matter, for no law can be enacted or supposed to be without an enabling clause from the Constitution of the state or the United States of America. The court does not have a contract with a party until the party gives the judge his or her name. Until the time, the judge is merely an actor in a black robe. The contract the court is trying to get the party with the party is to contract the party under the foreign jurisdiction flag. Oh, so the contract the court is trying to get with the party is to contract the party under the foreign jurisdiction flag. See chapter on the flag in the court. As the judges do not file their oaths of office into their courtroom, thereby acting under administrative law, whatever they want it to be. The laws passed since 1926 have all been sent by the President for the British Accredited Registry, BAR, from the state of New York, making all laws come under the BAR, so they are nothing more than bar codes, rules, regulations, statutes, procedures for the corporations to follow. The only way you have of making the judge uphold his oath is to file it into the case and restrict him to the law that you want to follow. There are 7 demands for discovery questions to ask all lawyers, attorneys, counselors, esquires. Number 1, please produce the legislative act and its implementing regulations that precipitate this cause or case. Number 2, please produce the legislative act that created the office of lawyer, attorney, counselor, esquire. Please give me the address of this office where I may go and get a license for practicing law. Number 3, please produce a copy of your oath of office as an officer of the court and where you filed it into public record. Number 4, please produce the contract signed by myself, proper name of the living soul, and you, name of the lawyer, in which I agree to give up my constitutional rights. Number 5, please give me your name, address, and phone number. Number 6, please give me your bond number and your bonding company. Number 7, please send to me an acknowledgement that you understand that you have perjured your oath of office and are committing constructive treason against the Constitution of the United States of America, the state of Texas, and the American peace flag. Now, to bring to mind, here, every time I'm reading this, it's always referencing the United States, united with a lowercase u. So it's lowercase u, N-I-T-E-D, all right, and states, capital S, lowercase t-a-t-e-s, all right, so that's what that's doing. So Keep that in mind. Under this system of consent, under this system of consent, a living soul never has to accept the ruling of the court, but they must object at all times to the action being taken. All persons spending time in prison were sent there by their own words. They did not ask for allocution. Example, judge, did you receive a fair trial? Answer, yes. The party is just being railroaded. Did your lawyer fight hard for you? Answer, yes. Do you feel that 12 years is a reasonable sentence? Answer, yes. They have just sentenced themselves to prison. This is aided and abetted by the parties. Lawyers who has told the party to be nice to the judge in the sentence phase of his trial, and tells the party that she understands the judge is going to probably give him a 12-year sentence instead of the 50 he could get. The other part of the problem is with the laws, or in today's court, the total lack of laws. The charge and intent are lumped together in one charge, and you cannot plead innocent. You must plead guilty, not guilty, no contest, thereby giving the court jurisdiction. All the courts have been lumped together into one court: administrative, admiralty, and civil. Oh, Jesus. All right. So I'm going to read that again, and then I'm going to have to jump into something else real fast. All of the courts have been lumped together into one court: administrative / admiralty and civil contract / commerce. With the advent of your plea, you go under administrative, any law they want to use to convict you. Anyhow, I've noticed in Aurora, Colorado, that the district courts, the county courts, and everything else are all lumped together. Okay? There is no separation to them. I thought that was interesting. All right, moving on. In order for a law to be construed as law, it must have an enacting clause from the source the law came from. That is, king, legislature, etc. All laws proceeding from the state legislature must have an enacting clause. Be it enacted by the legislature of the state of Texas, a legislature can only introduce a bill. It cannot introduce a law. It must go through, be approved unanimously by the House, signed by the leader of the House, be approved by the Senate, signed by the leader of the Senate, approved and signed by the governor, and the bill becomes law. Now, it is checked against the Constitution to find the enabling clause from it was written. Now, it is checked against the Constitution to find the enabling clause from where it was written. See, there's some typos here. If the Constitution does not allow for the law, then it is void from its inception. Have you ever heard a party? Have you ever heard a party? Let me guess. Who can challenge the enacting part of the law or the subject matter, jurisdiction of the matter he or she is being tried for, violating at any time for the trial or upon conviction while in prison? Usually it is not a law a party is being tried for breaking, but a code, rule, or regulation, or breach of contract. The proper response to "you have been sued" is the redemption process or rejection, returning their contract unsigned in full accord with truth in lending. Never let an attorney or lawyer send you any document without accepting it for value, or returning without a signature in full accord with truth in lending. They may say anything to you in their first letter, and you may think it is harmless. A rattlesnake seems harmless and makes a pretty noise, but it's deadly when it strikes. Have you ever heard the phrase, "You don't need to respond"? Do not believe it. Respond with the redemption process or reject. Return without a signature in full accord with truth in lending. Don't contract with third parties. Tell them to get lost. Tell them that they are fired. We now understand that the government gains power of attorney over us when we are born, and they take our birth certificates and make negotiable instruments out of them. We now know that through the Social Security Administration and the issuance of the number, we are recorded as a trust, and the living soul is made the trustee of the straw man the trust created. We now have our own power of attorney in fact, and we now know which form to fill out our for our taxes. We have already won. Steps taken for redemption. Step 1. Read all papers concerning redemption, especially read and reread public versus privates. Step 2. Fill out and file your UCC-1 and the security agreement for the straw man, a transmitting utility, and do all other documents. Step 3. Remove yourself from the voter registration with the enclosure form. Step 4. Accept for value any document that purports placing the obligation from the government for you. Let me read that again. I'm going to read it a different way. Step 4. Accept for value any document that purports placing the obligation from the government to you. All right. Step 5. Write across the original document sent for you the accepted for value statement. Step 6. All letters in the book that you will need. No. Step 6. All letters are in the book that you will need. Step 7. Send back the original document with your letter UCC 3-419 HJR 192 Power of Attorney in fact. Step 8. Make out your bill of exchange. Example is included. A. Invoice number is the first letter of your three names, Jack Rabbit Patriot JRP, plus date May 21st, 2001, 052101, and bill of exchange number, example, Jack Rabbit Patriot, so the letters JRP 052101, dash bill of exchange, so BOE 1001, period. B. Postage certified account number, certified mail number used for mailing for Treasury. C. Account number, first letter of your three names, Jack Rabbit Patriot JRP UCC1, number issued by state, date May 21st, 2001, and case number or document number, example JRP 052101 UCC 1-00898745 3-45 C, capital C, that is lowercase I, lowercase v, kind of in italics, dash 199 dash G, period. D, debtor and location. Person bill of exchange is for an address. There you go. All right. So let me repeat that, please. D, debtor and location. Person bill of exchange is for an address. E, value of bill, whatever you make it, should be substantial. Let your imagination run away. F, sign as creditor for the straw man. Include your power of attorney in fact. Step 9, any additions for the UCC 1-1 is made through the UCC-3. Nice. Step 10. Any action or case taken after the filing of the UCC-1 must be filed on the UCC-3. Step 11. Any bill of exchange written as an acceptance for value result must be registered on the UCC-3. Step 12. Mail bill of exchange stamped original to Secretary of the Treasury and wait 10 days. Then mail debtor and location a bill of exchange stamped copy. Use examples in the book. Redemption history. There have been so many papers written about the redemption process, and yet there seems a lack for understanding the basic concepts. Redemption was the initial path taken by people who know they are free but see no hope in the judicial system as it is practiced. It is vitally important for understanding how the people in the government turned our lives upside down and have made us believe that we are subject under them, when in reality they are subject under we the people. Every being is part and partial for we the people. The important points. Number 1, In 1871, the federal government formed itself into a corporation and pulled itself from under the Constitution. Number 2, in 1913, the Federal Reserve Central Bank were created. Central banks were created in 1913. All right. Number 3, in 1933, President Roosevelt put into effect the Trading with the Enemies Act. This applied only for federal citizens. Number 4, in 1933, President Roosevelt took the gold away from the people, although they were not required for giving it away, thereby leaving the people without money for paying debts with. Number 5, in 1933, President Roosevelt passed H.J.R. 192, June 5th, 1933. Simply put, since the government had taken the gold, the people had no money. The government would pay the debts for the people, dollar for dollar, thereby giving the people unlimited credit. Number 6, in 1938, Erie Railroad versus Tompkins made contracts the rule in our courts. In 1946, we lost our government in courts through the Administrative Procedures Act. Number 8. In 1965, silver was taken away as a means of paying debt. The UCC became the supreme law for America. Concerning the banking system, the courts were pulled together in administrative admiralty and civil contractor commerce / corporation, and the act and intent were brought together, thereby taking away your plea of innocent. You had to prove there was no innocent. Guilty until proven innocent. Changing the often quoted, you are innocent until proven guilty. Redemption definitions. From Zandervan's Pictorial Encyclopedia for the Bible. Redemption. Redemption is deliverance from the power for alien domination and the enjoyment for resulting freedom. It involves the idea of restoration for one who possesses a more fundamental right of interest. The best example for redemption in the Old Testament was the deliverance for children for Israel from bondage for the dominion for the alien power for Israel. From the Expanded Vine's Expository Dictionary for the New Testament words seems it supports Zandervan with this definition for redemption. A, in the natural sense for delivering. Luke 24:21. For setting Israel free from the Roman yoke. Redemption, in reference for the United States, is capturing the straw man, the transmitting utility from the natural living soul for the corporation or commercial, a third party, using a state birth certificate with an all-capital name, a fiction, appearing as your name given at birth, with you, the natural person, as the pledge for your energy, and surety for any charge made against a straw man. Freedom comes with the filing the UCC1 claim against the straw man and the subsequent acceptance for value for the state birth certificate for the governor in the various states for the union, thereby making him her the surety or grantor for any actions against the straw man. Redemption? Why? How? When? Where? Long before the States United of America was formed, a conspiracy of slavery has always been forced upon men by other men thinking that they can live and tell other people how to live, when they cannot even live their lives in freedom. For with the subjection of others to slavery, the slave master becomes the slave to the very people they enslave. The object is power through money, an illusion. If everyone works and pays another who does not work part of what they earn through taxation, the slave master becomes very rich in power and money. In an illusion, all people come into this world with nothing and they leave with nothing. Man was made to be free, subject only to his Creator and the rights of all men on this earth. To restrict the rights of another restricts the rights you have. Give total freedom to others in your actions towards them, and you in turn enjoy freedom as it was given to each of us. When we are critical of others in the way they are living, we are in bondage to that person. Any act done to another person or their property restricts your rights by restricting your peace and joy on this earth. Our story begins in the 13 colonies with the forming of the United States. The mechanism was already in place to bring forward the deceit of lies that has plagued man since the beginning. The illumined ones chose May 1st, 1776 as their day of birth in the United States of America. This statement was made in 1782. This nation that is now being formed 200 years from now will bring in the one world government, and the seat will be England. I thought it was wrong, but okay. The very men who were given credit for the founding documents, in a large part, not all, sent here by King George through loans from him, or simply with the intent to once again let men think they were free, when in reality the country was already being prepared for subjection by the state. All but 6 of the signers of the Declaration of Independence were dragged from their homes in the middle of the night and brutally murdered. Such is the price of freedom. What we know as the Constitution was written and presented to the colonies as a declaration. A declaration cannot be amended. The British Accredited Registry, or Regency, the bar, located in New York, changed it into a constitution. So the Declaration was changed into the Constitution. Okay. Much like the books of the Bible were changed into chapters and verses, it makes it easy to argue and change or amend. The people were taught to change it from the Constitution back to the Declaration and vice versa. There were 18 copies of the original, but as each were located in the archives of law libraries, the libraries were burned to the ground. The practices of converting and reconverting continued through the Civil War and then stopped. In 1871, the District of Columbia, the D.C. Corporation, was formed outside the Constitution and put into operation. Then through the money manipulation in the early 1900s, and especially 1913 with the passage of the Federal Reserve Bank Act, a private banking system which created a central bank for the nation, those men worked their behind the scene trickery. The Wizard of Oz. The 1929 crash of the stock market by draining the money out of the system, and the subsequent Great Depression. With the election of Franklin Delano Roosevelt, March 9, 1933, the Trading with the Enemies Act, part of this deceit of lies, came into being when the government took all of the gold from the people and made it a crime to own or hoard gold. The people of the United States of America lost their money, their ability to pay back, or to pay a debt, and they lost their law. That's dirty. I think I'm going to re-emphasize that by rereading a little bit. When the government took all of the gold from the people and made it a crime to own or hoard gold, the people of the United States of America lost their money, their ability to pay a debt, and they lost their law. For it is with the ability of the people to pay their debts with money that their power to establish law comes from he who owns the gold rule and establishes the law. At the same time, the government declared all property in the United States as belonging to the government and was to be used for the good of the government. They were speaking in a federal sense. The people thought they were talking to the 48 states. Only the federal government went bankrupt, not the 48 states. The federal corporation was not brought from under the covers, and everyone was convinced that the answer was here. The federal corporation was now brought from under the covers, and everyone was convinced that the answer was here. The deceit presented to the American people was now in full force. The governors of the 48 states of the United States all gathered at a meeting with the birth certificates of all the citizens of their states in hand and pledged the energy behind the stocks, bonds, and notes created by the federal government, who then sold them to the Federal Reserve Board, and at the same time placed, like dollars, of the Federal Reserve notes to ensure the payment of the stocks, bonds, and notes. The problem was the people could not pay a debt with a debt. Federal Reserve notes with the permission or consent by assent of the people. The deceit was, how do you get people to consent to put debt instruments against their property or assets? So it's a signified debt. The dollar is already representing debt. So when you sell your home or your automobile or anything, you can sell your children if you want to. If you sell them, those things dear to you and those people dear to you, because money, people do anything for money, right? What are you getting? You're getting debt back, and you think it's value. Why? Because of what you're able to do with it. That's pretty sick. All right, well, let's continue. All right. By creating the deceit was, how do you get people to consent to put debt instruments against their property or assets? All right. By creating a democracy form of government, in simple terms, is nothing more than a commercial corporate contract form of government, which cannot do anything but create debt. They then could not take the republic form of government away. They had to have a way to pay their debts. House Joint Resolution 192, passed June 5th, 1933, took care of the matter. The people were to be ruled by public policy, which is common law or anything that is established that the people will accept. HJR, which is House Joint Resolution, HJR 192, June 5th, 1933, established the public policy for the money that the people now did not have. Number one, the government would pay the debts of the people dollar for dollar. This would be done with credit, and the only people who could issue credit was the Federal Reserve banking system. Number two, the people were to be given preferred stock in this federal corporation. The people were to be given a prepaid account in the federal corporation. The people, number four, let's see. Yep, I forgot. Okay, so the people were to be given preferred stock in the federal corporation. Number three, the people were to be given a prepaid account in this federal corporation. Number four, the people were the holders in due course of the federal corporation. Number five, the people were to be exempt from levy. The people were then created into corporations or fictions through the birth certificate, social security number, and voting registration. Through these fictions, the stocks, notes, bonds were created. The credit to pay the debts would be established by the signature of the people, money created out of thin air. The bank never loans money, only credit. Since Federal Reserve notes are debt notes, they are all liability to the Federal Reserve banks. The deceit for the Federal Reserve Bank, or the deceit of the Federal Reserve Bank and their agents, all corporations only. A corporation creates debt. It is a fiction, an illusion. It is to get the people to allow them to place Federal Reserve notes against their assets without directly saying so. For it is a felony for anyone to request or accept Federal Reserve notes in payment of a debt. You cannot pay a debt with a debt. With the passage of the Social Security Act, the real deceit began. The federal government would now take care of you from the cradle to the grave. The Social Security Administration was created as a trust. The people apply for Social Security card numbers, and the Social Security Administration then, as grantor, establishes each person as a trust, or a fiction, or a corporation. The name is capitalized, such as Jack R. Rabbit, Patriot, is placed into the trust with the natural person Jack Rabbit Patriot as the trustee. All trusts or corporations report to the Internal Revenue Service through the form, or a form 1041. We as trustees are told to file a form 1040 as a federal employee and are charged income tax. We should be filing out the Form 1041 and no taxes paid or owed. Remember, we are tax exempt. All of the people are now held by power of attorney in the bar. In or about 1938, a ruling on Erie versus Railroad, or Erie Railroad versus Tompkins, changed forever the American justice system. Simply stated, without a contract, there is no case. Contracts became the sole basis in the federal corporation system and the court system. As the federal government is commercial, they deal in contracts. All cases in the courts are viewed as contracts. In or about 1939, the Bar Act was established in all the states, and all attorneys, esquires, lawyers, counselors had to join the bar, get a number in order to practice before the courts. They do not have a license, for to do so would subject them to the state giving the license. The state government is the only one who can license, not the bar, or the Supreme Court of the various states. Any attorney lies when she tells you they have a license to practice law, for the document hanging on their wall says certificate. In 1946, another monumental change came about with the entire American system of government, when a fourth branch of government was established with the passage of the Federal Administrative Procedures Act. And every corporation, which now includes all cities, towns, schools, districts, etc., dioceses, now sets its own rules, regulations, codes, statutes, and procedures. As rules, regulations, codes, statutes, procedures are not law. They can change at the whim of the administrator of the agency, so long as they do not violate the Constitution of the United States. These are simply bar rules, regulations, codes, statutes, procedures, since the president of the Bar of New York has signed off on all of these rules, regulations, codes, statutes, procedures since 1926. In and around 1970, 71, 72, 73, everything changed in the court system. The charge and intent came together, and a person could no longer plead innocent because he had to prove that he did not intend to do something, which is impossible. You now could only plead guilty, not guilty, or no contest. At the same time, all the courts were brought into one court, and they became administrative, admiralty, and civil, meaning commercial/contracts. We are brought into the courts, and when we plead, we have admitted we understand the charges against us, and the system comes down upon us. The people can never have a charge brought against them, only a claim. But the instant you say guilty, not guilty, or no contest, you accept a charge. Our courts are common law, and our law is established in the county you live in, for the county is your seat of government. You establish your case through affidavits and enter them into your county record, which becomes public policy concerning your case. You wait 30 days, and if the affidavit is not rebutted, you enter a default into the county record, make out an order for the county judge, and have her enforce your judgment. The government officials are called constitutors, which means anyone who swears an oath to pay the debt of another. The government has been putting their obligation to pay our debts back on us, thereby the acceptance for value. Read this again and again. File your power of attorney, in fact, to gain your standing in the law. File your trademark copyright to make attorneys pay who would violate your statement. File your UCC-1 claim on the straw man's assets and study the redemption process, and you will not only gain your freedom, you will know you are free. Beautiful. Government, to forever remain inviolate, to guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government, and shall forever remain inviolate. And all laws contrary thereto or to the following provisions shall be void. Texas Constitution, 1836. The Bill of Rights of the Texas Constitution has never changed. They cannot. The land will forever remain with the people. How long is forever? The last line and on all our patents on the land of Texas states the state of Texas relinquishes all hold on this land forever, and was signed by the then governor. How long is forever? All right, I will just continue at this point, and proceed in a later video. Hope you enjoyed it. Thanks for tuning in.